In this video, we are going to deal with the important judgment titled as Salimbhai Hamidbhai Menon versus Niteshkumar Maganbhai Patel and another, pronounced on 31st August 2021. This judgment deals with that the procedure of oral direction not to arrest an accused is irregular. To know more about the case synopsis, please watch the video fully. The facts of the case would be that the accused approached Gujarat High Court by filing a petition under section 482 of the CRPC seeking quashing of FIR lodged against him under sections 405, 420, 465, 467, 468 and 471 of the Indian Penal Code. When this petition was pending, the accused was arrested. When the proceedings were taken up after this arrest, the court noted that an oral direction was issued by the court restraining the arrest, and thus the judge directed that the accused should forthwith be released. This order has given rise to the appeal before Supreme Court. The learned counsel appearing for the appellant points out that the High Court was not justified in issuing a direction restraining the arrest of the accused till the next date of listing without reasons. The Supreme Court has held that the procedure followed by the High Court of issuing an oral direction restraining the arrest of the accused was irregular. Oral observations in court or in the course of a judicial discourse. The text of a written order is what is binding and enforceable. Issuing oral directions restraining arrest does not form a part of the judicial record and must be eschewed. Absent a judicial order, the investigation officer would have no official record emanating from the High Court on the basis of which a stay of arrest is enforced. Oral directions of this nature by the High Court are liable to cause serious misgivings. Such a procedure is open to grave abuse. Absent a written record of what has transpired in the course of a judicial proceeding, it would set a dangerous precedent if the parties and the investigation officer were expected to rely on unrecorded oral observations. The procedure which was followed by the single judge must therefore be eschewed in the future. While an order granting a stay of arrest in a proceeding under section 482 of the CRPC lies within the jurisdiction of the High Court, the grant of such relief must be after a judicious application of mind, which must emerge from the reasons which are recorded by the judge. The formulation of reasons in a judicial order provides the backbone of public confidence in the sanctity of the judicial process. While directing that the proceedings ought to be listed on a future date, the High Court is undoubtedly not expected to deliver a detailed judgment elaborating upon reasons why a stay of arrest has been granted. But the reasons recorded by the court must reflect an application of mind to relevant facts and circumstances. The High Court has not alluded to the allegations made in the FIR. This constitutes a serious deficiency. The petition before the High Court is for quashing the FIR under section 482 of CRPC. While determining whether to grant or ad interim relief in such a case involving a stay of arrest, the High Court must bear in mind the parameters for the exercise of the jurisdiction for quashing which has been invoked. The interim order of a stay of arrest is in aid of the final relief which is sought in the petition. Hence, the considerations germane to the exercise of the jurisdiction to quash an FIR must be present to the mind while deciding whether an interim stay of arrest is warranted. What is present to the mind must emerge from the text of the order. In the present case, the petition for quashing is still pending before the High Court. At the same time, the High Court was moved for the grant of ad interim relief in a petition for quashing the FIR. The considerations which ought to weigh in whether or not to exercise the jurisdiction to quash must be present in the mind of the judge while determining whether an interim order should be made. That these considerations have been borne in mind can only be evident from the reasons, however brief, which have been indicated in the order of the High Court. This does not emerge from the impugned order of the High Court, which is set aside herewith. Friends, to conclude, in this video we have seen that the procedure of oral direction not to arrest an accused is irregular as per Salimbhai Hamidbhai Menon versus Niteshkumar Maganbhai Patel and another case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.